can somebody be charged with a DUI if they're sleeping in their car and they weren't actually driving? So you get out of the bar, you realize you're too impaired to drive. You say, you know what, I'm gonna go to sleep in my car and just sleep this off. And you're in the bar parking lot, and the cops roll up. They see you in there, shine the light on there, and ask if you've been driving. Could you be arrested for a DUI at that point?
Of course, you can always be arrested for a DUI. It's whether or not the charges are going to stick. That's the perfect type of situation. Obviously, in order to be guilty of DUI, you have to be driving, right? Driving, though, is broadly defined under Pennsylvania case law, and it can mean that you're in what's called actual physical control of a motor vehicle. Actual physical control can mean that the driver is slumped behind the wheel of the car, keys in the ignition. It can mean that could rise to the level of driving for purposes of being charged with DUI. But the law says that something more is needed than a driver sitting behind the wheel of a parked vehicle with the key in the ignition. There has to be some evidence that the vehicle was actually driven while the driver was impaired. So in your situation, client leaves the bar, gets behind the wheel of the car, realizes that they're too drunk or too impaired, and then they pass out, and then they're arrested for DUI. Well, where's the evidence that the client actually drove the vehicle? The client was at a bar, that bar served alcohol, then the client left that bar, but never moved the car. In that type of a situation, there's no other evidence except for the client sitting behind the wheel of a parked vehicle. And so I would argue that there's no DUI. And so we see that type of a situation a lot. And the best type of a fact pattern for this scenario would be outside of a bar or some other establishment that actually serves alcohol. That would be the best situation.